Hi, I'm Steve Schwinn. I teach constitutional law at the University of Illinois Chicago John Marshall Law School. Today, the Supreme Court ruled in a really important decision that Congress violated the separation of powers when it created an independent director of the Consumer Financial Protection Bureau. Let's take a look at that opinion. Congress created the Consumer Financial Protection Bureau in 2008 as part of the Dodd-Frank Act in reaction to the financial meltdown. It vested the CFPB with authority to enforce 18 different consumer financial protection laws, whose enforcement had previously been dispersed throughout the federal government. It created a single director of the CFPB and provided that the director served for a period of 5 years and could only be terminated for cause. In particular, Congress said that the director could only be terminated for inefficiency, neglect of duty, or malfeasance in office. Now, this is one of the ways that we can create independence within the executive branch of the government. Congress can require a cause showing before an official can be terminated by the president or another executive branch official, and in that way insulate them from at-will firing at the whim, or in particular, the political whim of the president or other executive branch officials. The claim in the case was that this higher level of showing for terminating the director of the CFPB, that interfered with the president's authority under Article 2 of the Constitution, in particular the president's authority to enforce the law. The Supreme Court agreed with that. What the Supreme Court said was, by requiring a higher showing to fire a single director of an agency with as much power as the CFPB, Congress has impermissibly intruded on the president's Article 2 power to enforce the law, because it prevents the president from terminating that person at will. The Supreme Court acknowledged that the court itself had previously upheld a higher level of showing for particular offices in the federal government. So, for example, the Supreme Court said in Humphrey's Executor, we upheld a higher level of for-cause showing before a member of the FTC could be terminated by the president. But what the court said was, in Humphrey's Executor, the FTC was a board or a commission. It was several members with overlapping appointments so that they could check and balance each other. And moreover, it said the CFPB has a lot more power than the FTC did back when the court ruled in Humphrey's Executor. The court also looked to a case called Morrison v. Olson, where the Supreme Court upheld the for-cause termination provision for the independent counsel. What the court said was, in that case, the independent counsel was an inferior officer who could be terminated by the Attorney General. In contrast, the director of the Consumer Financial Protection Bureau is a principal officer who can only be terminated by the president. And insulating a principal officer from at-will termination by the president, well, that goes too far, the court said. And in that way, this case is different than Morrison v. Olson. The dissent in the case disagreed. The dissent said, look, the text of the Constitution provides support for Congress to regulate the size and shape and the way the executive branch operates to the extent that it doesn't interfere with the president's Article 2 powers. Moreover, this is the kind of thing that we've done throughout our history. And as we know, in constitutional interpretation, what we've done before is a good indication of what we can do now and in the future. While the majority in the case said that the for-cause termination provision for the director was unconstitutional, it violated the separation of powers, the court nevertheless left the CFPB itself intact. What the court said here was that the provision providing for-cause termination for the director was severable from the rest of the act that created the CFPB. So the court could retain the rest of the act in the CFPB, but carve out the for-cause removal provision for the director. This in turn means that the CFPB itself stays in place and the director stays in place. The only difference at this point is the director can't be terminated only for that higher level of showing. The director has to be able to be terminated by the president at will. So why does all this matter? Well, it matters because as a matter of separation of powers, it moves power from Congress to control the configuration of the executive branch. It moves at least some of that power back to the president, him or herself, to control the configuration of the executive branch and decide who to fire when, at least with regard to principal officers. Now, the ruling does leave some room open for the idea of independence, congressionally created independence within the executive branch. It leaves it open insofar as Congress creates an independent board or commission or some other kind of body with multi-members without a ton of authority like the CFPB had. Or it allows Congress to insulate individual inferior officers in the way that Congress did with the independent counsel in Morrison versus Olson. But what it says quite clearly is that Congress cannot create an independent single head of an agency that has a lot of responsibility and that serves as a principal officer within the executive branch. I hope this has been helpful in unpacking today's decision, and I look forward to seeing you next time. Thank you.